after. All right, so you're Jasmine Hancock?
Good enough.
And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April, well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25, DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? No. Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think
bond.
if you just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well.
Yeah, he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that?
Yes, ma'am.
How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you need to behave in jail?
No, ma'am.
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient, and in that case I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
JamayshA.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her, through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. It should be on its way. All right, sir, in cause number 24, DCCR 1791, I also have a motion to revoke your unadjudicated probation. This one shows you were placed on probation September 24th of 2024 for theft of a firearm, a third-degree felony, and that was also a 5-year deferred probation. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of unlawfully carrying a weapon May 12th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 3 alleges that you committed the offense of a minor in possession of alcohol May 25th of 2025, and is that true or not true?
True.
And then the state is abandoning 4, correct? In each case. Count 5 in each case alleges that you committed the new offense of resisting arrest or transport May 27th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you failed to report as directed to the probation department February 10th and May 15th of 2025, and is that true or not true?
True.
Count
Just
So we can amend it if you want.
All right, state abandons 7 through 10 in each case.
No objection.
Did you enter your pleas of true in each case to counts 1 through 6? I'm sorry, minus 4. So 1 through 3 and then 5 and 6. Did you plead true to those freely and voluntarily? And did you plead true to those counts because they're actually true? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've reached in each of your cases that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your pleas of true in each case freely and voluntarily to counts 1 through 3 and 5 and 6. Find those counts true. Find sufficient evidence in each case to find you guilty. And cause number 23, DCCR 1801, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1791, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm, 3rd-degree felony. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you, and you need to listen carefully to this one because I'm not sure what's going on with you and all this gun stuff. Apparently you think it's cool to steal guns, have guns when you're not supposed to, and it's landed you now going to prison at, how old are you? 20 years old. You're going to prison because you can't keep your hands off guns, really. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you possess a firearm or ammunition, charges could be filed against you, and those charges are 3rd-degree felonies. So if it's no more UCW, unlawful carryings. It's a 3rd-degree felony, felon in possession of a firearm, because you're now a felon. Do you understand? If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, I'm handing you the trial court certification in that document now. I'm also going to sign, as part of the agreement, a dismissal in cause number 25, DCCR 0868. All right, you can go back with the bailiff. Oh. All right, ma'am, are you Toy Hill? And Ms. Hill, you were previously in court, entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has yours.
Are there any additions or corrections?
Not from the defense, Your Honor.
Not from the state, Your Honor.
My inclination, if I'm going to follow this agreement, is possibly, based on some of the statements of family members as well as probation, is special needs safety. There's obviously some thank you so much. There's obviously some drug history and abuse of several different things in that list, as well as some mental health issues that need to be taken care of. And I think to get started on this probation, if I'm inclined to go along with it, that's what I would be inclined to do. Do you want to?
Yeah, can I get a minute?
Yeah, visit with her about that, but that's based on the history, with same types of offenses. That's where I'm headed. So y'all can visit for a minute and then I'll take care of it, just so she knows what I'm talking about. Mr. Cashin and Mr. Johns on Larry Williams.
Larry Williams.
Good morning again, Your Honor.
Good morning. Morning, Mr. Cashin.
Good morning, Your Honor. How are you?
Great, how are you?
So far, so good. Better than a lot of people.
That's true.
Just than a few. And this is Mr. Williams.
Good morning, sir. You're Larry Fitzgerald Williams. And in cause number 25, DCCR 0985, Mr. Williams charged with capital murder. And then the other case is a motion to revoke probation that Mr. Johns represents him on in cause number 24, DCCR 1790. It's not a motion to
That's not a
revoke
motion.
probation. I'm sorry. The other case is an aggravated assault causing serious bodily injury. And so, Mr. Cashin, obviously your case is the top one on that. What is your announcement?
We are not ready to proceed yet. We need to get all the information from the DA's office. We have to review some of the evidence that they have provided. We want some phone records. I'm going to get with ADA about some of the phone records, the forensics on his cell phone, the forensics on the phone of the decedent, and a couple other things that we have to do.
And do you have everything in your possession to turn over at this time that you know of, Mr. Smith?
As far as I know, Judge, we do.
Okay. If y'all will just get together and visit about that, if there's something that Mr. Cashin needs that you don't have, if you'll get with law enforcement, let's get everything. And then what I'm inclined to do, just based on upcoming holidays and things like that and resets, I'm inclined to give a longer reset, but I don't want y'all to wait till the last minute. If I do that, go ahead and get everything, visit. I'm going to do a reset to maybe that first week in January.
Yes.
That should give y'all plenty of time, hopefully on a case of this nature, to get more up to speed. And then I'd like an announcement if we can on that
That's
date.
kind of what I was expecting.
Okay, sounds good. Then we'll see you back then.
Thank you.
Thank you, sir. You're free to go.
Thank you for
You can go back with the bailiff, sir.
Thank you. All right. Thank you, Your Honor.
Yes, sir. Thank you. Ms. Holmes, are y'all ready? Yes. Let's go back on Toy Hill. All right, is everyone ready to proceed with sentencing?
Yes, Judge.
And Ms. Hill, in cause number 25, DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of assault family violence by impeding breath or circulation, sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete this special needs safety program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on this probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages, or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff.
The courtroom in Jefferson County, Texas, opens with the case of Jasmine Hancock, a defendant facing a long list of serious charges. The judge begins by outlining 3 separate cases against Hancock, 2 from April 2025 involving evading arrest and continuous violence against a family member, and a 3rd from August 2025, yet another charge of evading arrest with prior convictions. Each case paints a picture of a repeat offender, someone who, even after multiple run-ins with the law, continues down the same dangerous path. His bonds, previously set at $100,000, were under review after his attorney requested a reduction. But the record shows Hancock missed a court date in July 2025, which immediately led to his bond increase. The judge reminds everyone that when a defendant skips court, it isn't just a small mistake. It's a direct violation that triggers bond forfeiture. To make matters worse, there's a protective order tied to one of his older cases, signaling ongoing domestic issues. As the judge reviews jail incident reports, tension grows. Hancock's attorney attempts to argue that her client had gone to the hospital at the time of the missed hearing, but the judge isn't buying it. She points out that Hancock has 10 prior felonies, including firearms, drugs, burglary, and multiple evading charges, 7 of them in total. He had only been off parole for 2 months, the judge says, before launching into a stern lecture. The courtroom falls silent as she tells Hancock he's old enough to know better. She reminds him that disrespecting jail officers, threatening staff, and refusing to follow rules could lead to even more charges. Her message is blunt. You've lost your right to make decisions. You're looking at 25 to life. Keep it up, and a jury will see all of this. In the end, the judge denies all motions for bond reduction. In fact, she raises his 3rd bond to $100,000 as well. If Hancock manages to post bail, he'll be placed on GPS monitoring and house arrest, forbidden to leave home without court approval. She also imposes a strict no-contact order with the victim, Janesha Butler, warning that even a single message from jail could lead to harsher penalties. Next, the court moves to another defendant, a young man named Williams, only 20 years old. He's facing multiple probation violations and new charges, including unlawful carrying of a weapon and resisting arrest. One by one, Williams admits guilt to several counts. The judge sentences him to 5 years in prison for each of his 2 felony cases, theft of a firearm and evading arrest, but allows them to run concurrently, meaning he'll serve them at the same time. Before he's led away, the judge gives Williams a harsh reminder: you're going to prison because you can't keep your hands off guns. From now on, if you're caught with one, it's not a misdemeanor, it's a felony. She emphasizes that, under Texas law, Williams can no longer possess a firearm or even ammunition for the rest of his life. Finally, the focus shifts to Toy Hill, a woman previously convicted of assault family violence by impeding breath or circulation, a serious domestic offense. After reviewing her case and the pre-sentence report, the judge acknowledges Toy's struggles with drug addiction and mental health issues. Instead of sending her straight to prison, the court takes a rehabilitative approach. Hill is sentenced to 10 years in prison, but the sentence is probated, meaning she'll serve it on probation rather than behind bars. She must complete a special needs safety program focusing on substance abuse and mental health treatment. However, the judge makes it clear that if Hill violates any condition of her probation, she'll be sent back to serve the full 10-year prison term. The final warning is about her victim, Cheryl Johnson. Hill is ordered to have no contact whatsoever, not in person, not through calls, and not even electronically, and even if Johnson initiates communication. With that, the judge signs the paperwork, confirms her rights have been waived, and the case is closed for the day. In the end, Hancock's bonds remain at $100,000 each with stricter conditions. Williams is sentenced to 5 years in prison, serving both cases together. Toy Hill is given a second chance with a 10-year probation and mandatory treatment. Justice delivered, firm, fair, and final.